This is the January regular monthly meeting of the State Board of Education. Would you introduce yourselves, and I'll call your names so you'll know you're next. Sabina.
Sabina Brochu, student member, Williston.
Kim Gleason, are you aboard yet? I see not. Kathy Lavoie.
Kathy Lavoie, Swanton, Vermont.
Bill.
Bill Mathis, Goshen.
Oliver.
Oliver Olson, Londonderry.
Peter Peltz, are you with us yet? Guess not. Angelita.
Angelita Pena, student representative of Bristol.
Thank you. Jennifer.
Good morning, Jennifer Samuelson, Winhall.
Secretary French. I reckon you'll be joining us in due course. And I'm John Carroll from Norwich, chair of the board. Thank you all for being here so promptly. Let's get right into, let me just speak about amendments to the agenda. There are no, that I know of, amendments to the agenda. I do plan, however, to try to accelerate the rate at which we get through from here through to item J, which involves many of you reporting and all of us listening closely. The reason I'd like to try to accelerate things a little bit is item K, we only have 30 minutes for this. This is the executive session at which we're going to be briefed on the pending appeals. And I think we would like more than 30 minutes for that conversation. So I'm going to try to accelerate our work just a little bit. But I won't cut anybody short. We'll just move as quickly as we can. We will stop that discussion in executive session no later than 11:45. As I indicated to you in my email last evening, I want you all to have the ability, if you wish, to see the proceedings happening in Washington, D.C. today, which I think at least some of us think is a pretty important event. We will then get back to work. Probably we will start, if possible, at 1:45, even though we're currently scheduled to start at 1. We just got a lot to do today, and we've got to just pack in as much as we can. So let's move on to the consent agenda. The only item on the consent agenda is the approval of the minutes of the December meeting. Is there a motion?
Mr. Chair, I move that we discuss the minutes.
We will do so. Is there a motion to adopt the minutes?
So moved, Kim.
Kim, hi Kim, welcome aboard. Yes, Kim Gleason moves to adopt the minutes. Is there a second?
I'll second it.
Second.
Second, please, let's just speak right up. And now there is discussion. Would you go ahead, Jennifer?
Sure. So under item H, Rule Series 2220, it's on page 4 of the minutes. The first two paragraphs, in the first paragraph, it's a sentence toward the end. Chair Carroll said that once the rules are open, there may be other sections in the rules other than independent schools. I believe that's meant to say other than special education as it applies to independent schools. And similarly, in the following paragraph, the first sentence, Gleason made a motion to direct the chair to create a 3-member committee to examine the need for additional changes to Rule Series 2200 not related to, again, I believe it's meant to say special education as it applies to independent schools. Furthermore, and this is my last suggested amendment, which I can throw out there and then we can discuss all together if you think that's appropriate.
Yes.
Under item K on page 6, the second paragraph, I believe it is the second sentence, discussion followed that it be considered in terms of enhancing delivery and outcomes to students, capturing, and I think instead of the expensive students that attend independent schools, it might more appropriately be the number of students in poverty who attend independent schools. So that was my thought, and those are my suggested changes.
Very good. Is there a comment or discussion of the proposed changes? I would say they're good catches. As the maker of the motion, Kim Gleason, will you accept an amendment to your motion to say we move to adopt the minutes as proposed to be modified?
Yes, I will.
All right, then the motion before you is, shall we adopt the minutes in modified in the ways just indicated by the member Jennifer Samuelson? Those, are you ready for that question? Those in favor indicate please by raising your hands. And those opposed, seeing none. Jenna, was that you indicating approval or opposition? You're muted, Jenna.
Approval.
Approval. The motion carries unanimously. Thank you very much, Jenna, for the motion, and Jennifer for the careful reading and the good improvements to the minutes. Thank you. Are there board announcements? Then are there any student reports or announcements? We'll start with you, Sabina.
Yeah, so a little update on the mental health survey. Anilita and I met on Friday with a professor from St. Michael's College who is doing a similar survey kind of at St. Mike's, looking at students' mental health. And so she's provided us with some resources to kind of get questions that have already been used and have been successful in gathering information, so that way we don't have to come up with our own. And so from there, we're going to kind of put together an idea of what we are thinking, and we're meeting with her again on Friday to kind of show her what we've done this week, and hopefully that will be rolling out soon, and we will be able to present to you guys that information about the students' mental health. The other thing I wanted to bring to the board's attention, which is something more like personal, was that I know we had our standards-based grading information gathering a while ago. However, I recently had a personal experience with standards-based grading, and kind of the point that I made at that meeting was that why should kids put an effort at the beginning when those grades don't really matter? And so I was in my writing prose class, and we were assigned a research paper. And, you know, I put in so much hard work. Like, I have never worked harder on a writing assignment. And, you know, I get all 4s. It's awesome. And then we go to do our next assignment, and it's the exact same targets. And so all of that hard work and effort that I put into that research paper is not going to be shown anywhere, because those grades are just going to be replaced with my college essay. And so it almost like just shot me down a little bit and took away a part of like, yeah, I did great on this assignment and I got good grades, but that doesn't really matter in the long run. And so I kind of wanted to just share that, because I think that's something really important that people need to kind of keep in the back of their minds, that, you know, I'm sure this is happening to kids, you know, across the state who are, you know, high achievers, and they want to do well on every assignment, but they do well on an assignment, and then they're told, hey, this next assignment, you're just going to replace those grades. And it's like, well, why did I put in the effort there?
I'm going to sound like your grandfather when I say this. First of all, I totally get it. And by the way, it was just a year ago that you made this point at our meeting in Rutland, and it was a great point, and echoed, by the way, by several other students like yourself. And if your grandfather were here, he would say, well, but you did accomplish excellence. And that in itself is a great achievement and a worthy goal. It's small comfort when it comes to building your transcript for admission to a selective school, but it is also true. But anyway, thank you for that. That's a great report. Angelita, let us hear from you, please.
Hi. So nothing exciting has really happened. Basically, I've just been looking through the information that we got and just kind of writing down notes. I haven't put anything in our form yet, but yeah, for the most part, I've just been kind of brainstorming for that. And yeah, it's been a pretty boring, very calm month for us. I think everyone kind of been on edge for quite a bit, so nothing at school. I think everyone at school was kind of like, because we have such a very diverse, opinionated environment at my school, everyone's been kind of like, we're just gonna not talk about anything. So yeah, nothing exciting has really happened.
Thank you. You reported to us last month that there was sort of a no masks period, and also that there was some tension around Black Lives Matter.
Yes.
That's been resolved one way or another?
So the mask thing was resolved. I brought it up to the attention of the committee that works on that, and they basically said that they're going to write out something to teachers to clarify that it is kids have to wear masks, and if they don't want to wear masks, they have to go outside with a staff member. And the Black Lives Matter thing was resolved. We ended up voting unanimously to raise the flag, but we are expecting a lot of lashback from the community. And I myself have done a little bit of research into what other people think. And I think I don't want to ramble because I know I'm going to, but it's very interesting. I think this whole debate is we just need to learn to respect each other and our opinions. Because whenever I watch people debate about this, it's just like, I'm right and you're wrong. So I don't know. I'm going to kind of look into this a bit more and see if there's a compromise, if any. I don't think we should compromise, but I think for the good of the community, I think we should look into everyone's opinion. But yes, those were resolved, thankfully. But the Black Lives Matter thing, there's probably more to it that we're going to end up having to. And I'll give you guys updates if anything new develops on that.
I'm just grinning because I think you two student members are just a great blessing to our work. It's so wonderful to have you both. You're both such great young women. I consider you a great gift. Thank you very much. The time, I'm a little concerned about starting the public to be heard. We could do, but I'm a little worried that we're a little ahead of schedule, and I would hate to have any member of the public show up at 8:50 and find that they had missed their opportunity to speak. So I was going to suggest, I see some hands, I'll get right to you. I was going to suggest that I go ahead and do my little report, and then we could have the public. But first, I'll respond to the hands I see up. The first one I saw was Jenna. Go ahead, Jenna.
Oh, mine was very short. Sabina made another appearance on WCAX. I don't know if anybody saw her, but she did a lovely interview about playing hockey and the importance of sports, right, Sabina? Getting kind of back in the routine and getting back on the ice and the just the value that extracurricular activities, especially sports, have on you. So it was great to see you. You did an amazing job again.
Great.
Thank you. Actually, fun news kind of off that. We just had our first 2 practices with contact. So we were playing actual hockey and it was awesome.
I'd like to be your campaign manager when the time comes for you to run for public office. Who else has a comment? Jennifer, I think I see your hand, and then Bill.
Sure. Well, I was just going to take the couple minutes that we have here, but Angelita, it's interesting. Yesterday I went to a online conference with TJ Donovan. He was one of the guest members, and he's our state attorney general. And interestingly, he's a prosecutor, and so he litigates. But what he was talking about is that he really uses litigation as a last resort, and that he really believes in education and the concept that people really want to do the right thing, and it's a matter of educating people to help them understand, to expand their framework of understanding. So to your point about Black Lives Matter and how to sort of work through this, I would argue that a lot of it comes down to educating and creating a different framework for understanding different experiences, which gets back to what I see as a very important job for us as members of the State Board of Education. So I think there's a lot of room for growth. I think we have a lot of divisions that exist in this country that have sort of been covered over that are now opening back up again. And I think it's a real opportunity for us as board members, but community members as well, to really work with our fellow community members to increase understanding.
Thank you, Jennifer. And Bill.
Just quickly, getting back to that testing comment, I was wondering whether that was a state test or whether it was local test.
Sabina, I think that's a question to you.
And this raises the question, there's a good administration coming in, and they may be changing the annual testing program because of the disease. And any testing that we do would probably be pretty chaotic in terms of the results. So just something to keep an eye on.
Thank you, Bill. Be sure to take your hands down when you've finished your comment, please. Thank you. Kim, you have a comment or question?
Yes, thank you. I just wanted to let folks know that Addie Lepsner, who had reached out to all of us early on and is working through Student Network on anti-racism, their group received a grant, and they are looking at providing books to classrooms in the lower grades, K through 5, and reaching out to superintendents and principals to see where that might be beneficial in their classrooms. And they continue to work hard to further the cause and to connect around issues, especially related to curriculum. So I think we should all be grateful for the work they're doing, and I have the occasional opportunity to listen in and offer suggestions for whom they might contact and connect with to open doors to the extent that's helpful. So, but they really have continued to lean into this work and learn and listen and benefit all students, I think.
Thank you. Thank you, Kim. Sabina, your hand is up.
Yes, to piggyback right off of what Kim said, I went to one of the meetings, because I'm on that same emailing list, where we kind of were deciding what to do with that grant money. And it was actually really, really awesome because, it was like, we have this money, what do we do with it? And, we were like, what if we just, bought books for, schools that can't have it? So basically what they're kind of doing is they're working to find books about like anti-racism or that promote, conversation in the younger classrooms. So that way there are, students, it doesn't fall on high schools as much now in the future to feel like they need to educate students that, it's not okay to be racist in today's society. I'm sorry. And so that I just wanted to kind of share that, and that it's, from what I've seen, it's also amazing work. And I'm super proud of what she's done.
Thank you, Sabina. So thank you all for this rich and warm discussion. It's a lovely way to start our meeting. We're back on schedule again, and we can now open it up for the public to be heard. We're a few minutes early, but I suspect there's some folks on board. I just want to mention that Maureen Gatiss and Suzanne Sprague are both supporting this meeting, and we thank them both for their really, really effective and capable work for us. They make my life so much easier, all during the 30 days between every meeting, and they're always there to help us. So we thank them for that. Maureen, do you see if we have any public who wish to be heard?
Thank you, John. I see we have a couple numbers on there. I don't know if they're listening in or if they want to be heard. And Josh Doherty's on. I'm not sure if he's a member of the public that wishes to speak.
All right, then. Members of the public, I will invite you to speak. Let me remind you of the ground rules. The only topics that you may speak to are items on today's agenda. You're not welcome to offer comments on things that are not on today's agenda, number one. And number two, we really discourage you from offering your opinions on any topic that may come to the board in its quasi-judicial capacity. That is to say, wherein the board would be conducting a hearing or reviewing an appeal. Those are quasi-judicial matters, and just as you would with a court, you don't call them up and give your opinion about how a court ought to make its decision. Your views on topics such as that may come to the board as matters of appeal are frankly, we can't prohibit you, but they are certainly not welcome and they're not helpful. However, all other topics are welcome so long as they are on the agenda. Is there anybody among the public who would like to speak? Well, I guess that was a stifling introduction. I apologize if that was the effect. Any members of the public who wish to be heard, we welcome having your comments. We'll wait just a little bit longer, because it's just now turning 8:50, which is the time that the public had been notified that they would be able to speak. And I'm just checking my screen, and I don't see you, Angelita, but I do see a logo indicating that you're on. Good. So your screen is off. As a rule, if possible, we like to have the members be visible in video, keeping in mind my usual lecture to you that we are on TV. We are being taped. The public does go to the RETN website to see our meetings. And so we need to, I hate the term professional, but we need to be here and visible at all times if possible.
John, there are two other members of the public who just joined the meeting, so you may want to repeat your invitation for.
Thank you. Thank you, Oliver. We are standing by to hear members of the public, and this is a reminder that your comments are really welcome here. However, they must deal and address with items on this agenda, this month's agenda, not any other topics. Thank you. Please speak up if you wish to be heard. All righty then. Hearing none. By the way, Maureen, I don't see Secretary French yet. Do you know anything about his schedule?
I will check with him on that. Yep, I'll get right on that. Thanks.
Thank you. I'm just trying to foresee what kind of time opportunities we have. So I'm about to close the public comment period. Is there anybody in the public who wishes to be heard? Marie, do you see anybody indicating a wish to be heard?
I do not.
All right. Thank you. I think we've given it our best shot. And so in that case, let us move on. We're now at item E, the chair's report, and I will be brief. Much of my work in the last several days has been being in touch with legislators. And I want to just update you on where things stand with legislation that is of interest to this board. I can begin by saying that to date there has not been legislation introduced to address the disaggregation phenomenon that we saw with Halifax Reedsboro, and as you know, there have been not several, but a handful of local votes about disaggregation, or call it what you will, secession, divorce of union school districts. I have talked with the chair of one of the education committees, and he or she said that at the very least they might propose a moratorium. And this is something we might discuss when we get to the legislative agenda piece. A second piece of interest to this board is the weighting study, and Bill and Jenna both worked conscientiously on drafting a proposals, two, they each had one, about that, which you've received. To some extent, that our position about that has been made moot by the introduction of two bills addressing the weighting study. One in the House, I'm going to go from memory, it's H54, introduced by Representative Sibilia and many, many other members of the House, both Republican and Democrat, and from all around the state, interestingly. And it's a very, very comprehensive proposal. And basically, the proposal is, let's get going. Actually, let's start implementing this. It's very ambitious. It has then a mechanism for studying the initial stages of that implementation. The other bill is in rather sharp contrast, introduced by a single member of the Senate, Senator Baruth, who is the former chair of Senate Education and was the chair for, I think, as much as 10 years. He has left that committee and moved over to Appropriations, which is considered a very desirable committee to be on. I used to be chair of Appropriations. I can tell you, it may be desirable, but it's a ton of work. It's great work. But anyway, Senator Baruth has introduced a bill called S13, which is quite a bit shorter, and it proposes an analysis and study largely to be conducted by the Agency of Education, and the agency is obliged by the language of the bill to conduct its analysis and study in collaboration with the state board and other key stakeholders like the Principals Association, the Superintendents Association, and others. And so that's also of importance, and the two bills represent two quite different approaches.
Sorry to interrupt, John, but we're getting a lot of feedback and background noise from somebody dialed in on the phone. So I don't know, Maureen, if you can mute all the phone participants.
Yeah, I did hear that, and I just muted them all. So.
Oh, thank you.
Thank you.
Thank you, Oliver. Very good. Thanks. Welcome aboard, Dan. Happy to see you.
Good morning.
Good morning. I'm just finishing up my little thing on the chair's report, and I'm trying to save us some time in our discussion, which will come later, about legislative agenda. The other topic that's of interest to the board and especially to the chair is the legislative reform of the state board. Just to remind you, this reform is vitally important to the life of this body. You may remember in October of 2019, the Sunset Advisory Committee of the legislature recommended the elimination of the state board and gave us a stay of execution in order to respond to their concerns. Peter Peltz and I met with the Sunset Advisory Board and explained to them the reforms that we intend to implement, and that was, they were very glad to hear about those reforms. You'll recall that the Senate Committee on Education last year developed and advanced and passed unanimously reform legislation entitled a bill to reform the State Board of Education. And the main elements of that were to correct some language which essentially appeared to give the board authority to create policy, which is one of the reasons why we have created so many enemies in the State House. You just don't try to usurp legislative authority by creating policy. That is a no-no. And the board had been doing that for well over a decade. The Senate committee's reform would eliminate that, would shift some of the rulemaking over more appropriately to the Agency of Education, and would, at my urging, eliminate the board's micromanaging of some of the agency's decisions. A good example, snow days. The board has to sign off on snow days. This is foolishness. We bring no value to that discussion, but we can count on the Secretary of Education to manage that properly. So that legislation, of course, because it was the end of second year of a biennium, I don't know if you know the rule, any law, or any bill that is not approved by both houses and signed by the governor by the end of a biennium dies, no longer exists. And the next legislature, at the beginning of the new biennium, which is where we are today, if it wants to address that question, it has to go back to square one and start again. I've been assured by legislators in both the Senate and the House, and not what's quite encouraging is that the Sunset Committee is very enthusiastic about the bill that was reported out by the Senate Committee on Education last year. And that's a huge turnaround. These are the very people who put us on the execution list. And they are convinced and satisfied that this board is willing and eager to advance reforms in its own authorities, partly to unencumber the Agency of Education, and partly to avoid the temptation that the board has succumbed to in prior years of meddling around with creating new law. So it's very encouraging that there are many important players in both chambers who are eager to see this legislation move forward and become law. With that, I'll stop and welcome the Secretary to our meeting and invite him to present his report.
Well, good morning. It's good to see you all. Hope you're all doing well. Just sort of briefly, and I'll be happy to answer any questions. Firstly, just some observations on our COVID-19 context from the educational perspective. As you know, I participate in a lot of state level meetings on the topic. My conclusion is we seem to have navigated the holiday period pretty well. I mean, that was a topic of significant concern and planning on the part of school districts. And we know typically in our assessment of that, we wait for about 2 weeks after the holiday. So we're through the Christmas period where that would manifest itself in our data, and we're getting through the New Year's period as well. And sort of our view is that, cases are leveling off. For example, I would say cautiously optimistic about having gotten through the holiday period pretty well. But once again, as you know, Vermont is not an island, so we're very attentive to the regional trends as well. But one of the reasons for our optimism is also the fact that regionally our neighbors seem to be doing better as well. But there are a lot of unknowns, so it's if we're optimistic, it's very cautiously optimistic. For example, we're about to see the return of our college students to the state. And we're not sure how that will play out yet. We also, as you know, see a lot of tourist travel during the winter. So optimistic but cautious. We're also, a lot of information about the vaccine. I think it's fair to say we've had imperfect information from the federal government in that regard. It's been difficult to do good planning since our information's been fairly unreliable. We're hopeful here as well that we're going to start to get greater clarity in the coming days and weeks under the new administration. So that, this sort of optimism has manifested itself in our interest in hoping to return to more in-person instruction as we see a trajectory of hopefully conditions improving with the warmer weather and the vaccine beginning to make an impact. So we're starting to do some of that planning now. What we're calling the recovery phase in education, and that planning is started inside the agency, but now starting to farm out into working with some of our stakeholder groups on that. But we're going to take a sort of a cautious pace to that. Start to also reach out with our national partners in other states who might be interested in doing that work. But we want to begin to start to point the system towards, I'll call the recovery, which is, really bringing other state agencies and resources to bear to begin to address the impact of the emergency on students from an educational and perspective, and really contemplating the term education in that regard to include their broader social, emotional well-being, healthy development, and so forth. I will say another sort of cause for some optimism is we've received additional federal funding that was approved through Congress sort of at the end of the year. And that's going to be, I think, very helpful in this recovery work. Vermont, for example, we had one of the programs was called ESSER. You might remember it's Elementary Secondary Education Relief. That was part of the CARES Act. So what Congress did in this action was basically put more money into existing programs. So last spring, we had received about $30 million in ESSER. The bulk of this goes directly to school districts, and they have fairly wide discretion how they utilize the funds. This time around, we have $126 million in what's being called ESSER 2. So basically 4 times as much money being appropriated for that. So that'll be very useful as we get into recovery. And Congress is already starting to talk about additional support in the spring as well. So I think we'll be in a good place to start doing the planning for the recovery, and also hopefully have the financial resources at the school district level to engage in that work. Lastly, I just thought I'd give you a real quick update on the current Hatton situation. I have appointed members of a review team. That appointment process was delayed, or the identification of those individuals delayed somewhat due to the holiday. But that work's now going forward, and I'll keep the chair apprised, particularly that process points to me formulating a recommendation that could result in any action on the approval status of the school. So I think that's pretty much all I had in my report. I'd be happy to answer any questions.
Bill Mathis, I realize now that your hand has been up for quite a while, and I apologize. Perhaps your question was for the earlier topic. I don't know.
It was.
Okay. All right.
And so I think we'll return to it when we get to
agenda. Yeah, that's fine.
Further on the agenda.
Yes, thank you. Are there questions for the secretary?
Yes.
Jenna? No. Bill?
In terms of Senator Bruce, Bill, in terms of the waiting study, I'm worried about staffing and having adequate staffing in the agency. Perhaps we'll return to that later on, or if we could look at it now, that'd be fine too.
Sure. Mr. Secretary, do you have any comments about that?
No, I'm not familiar with the specifics of Senator Bruce's bill regarding the waiting study. But I'm certainly interested in the conversation and what the implications would be for staffing at the agency.
I did note in that regard that there is, to my recollection, there is no provision in the bill as drafted for funding. As you know, Mr. Secretary, it's very common when legislation places an obligation upon an entity of the executive branch to provide an additional special appropriation for that purpose, and we don't see that in this case. And it would be a substantial piece of work, there's no doubt about that. Kim Gleason, you have a comment.
Yes, thank you. I'm just wondering, in thinking about the concerns regarding staffing and capacity, are there currently open positions to be staffed, or is the consideration for any additional work really in need of allotting resources to new positions?
Yeah, I think it's a great question. When I arrived as secretary, we had 25 vacancies at the agency, and there was a fairly persistent narrative in the State House that we needed more positions. I would hear from legislators, both individually and collectively, for example, we're going to get you more positions. So my approach has been to really address the vacancy rate that we had, and I'm pleased to say we're more or less fully staffed. So we've made a lot of progress on filling those vacancies, albeit with COVID-19, there's been a hiring freeze implemented in state government, but we've been able to go through that process and see our hiring needs addressed. I think the other point I'd make, and it's I would say a point of some frustration, but your last comment of when new ideas, as I think it sounds like what was being contemplated with the waiting study, when new ideas are put on the table, I've been always very clear to say that I don't, I've been good about filling the positions I have, but I don't have spare capacity in the agency. So if there's new policy initiatives or work to be done, we need staff to do that work. I don't have people sitting around, particularly with COVID. I mean, we've taken on a tremendous amount of, say, administrative work to implement response. So there's been specific instances. Act 1, the ethnic studies bill, originally there was a version of that required some data analysis, and I said we're going to need staff to do that. And essentially the bill language was ultimately modified so that the staffing impact wasn't there. Lead in drinking water was another example where the one version of that was going to require us to really have some knowledge and management of school facilities. It's an area where we're woefully understaffed. We haven't, with the moratorium on school construction, at one time the agency had 3 full-time staff dedicated to managing just that program. Since 2007, with that moratorium, we have 0 FTEs dedicated to facilities in the organization. So every time the legislature has contemplated some new initiative, I've been very clear about advocating for new staff, and they've simultaneously not been as interested in doing that, as the chair pointed out. So it's somewhat of a conundrum, I would say frustrating point for me that I start the legislative process with them saying we need to get you more staff, but when they propose new ideas, they don't want to make sure we have the staff to do the work. So that's part of, I would say, the strand in my theme of this idea of policy coherence. It's like we can have a policy idea, but we have to have the parameters established about what success of that policy would look like, and we need to make sure we have the resources to do the work with fidelity, and also need to have some understanding of what else is on the table, frankly, at the same time. So it's been, I think, part of the other challenge is that we've been doing Act 46, Act 173, the data systems, all simultaneously with little contemplation as to what the aggregate impact would be on the organization's ability to keep its head above water. So anyway.
Just further to that, another example of a significant staffing demand on both the agency and the board was the proposal with regard to reactivating the state school construction aid program. And that required the board to go back and completely update its rules in this area. And those rules are highly technical. And it would necessarily be quite a project for the board. And beyond that, the agency had enormous responsibilities contemplated in the renewal of school construction aid. And I suspect that that's going to come up, if it doesn't come up this year, as soon as the pandemic lessens, I'm sure it will come back up, and we will be faced with the same challenge that the Secretary is describing, where we are asked to do important and valuable analyses, and it's almost as an afterthought that people think about where the resources are going to come from. Oliver, you have a comment or question?
Yes, thank you, Mr. Chair. Just an inquiry for the Secretary for some clarity. I heard, Mr. Secretary, you mentioned that you're sort of fully staffed or close to being fully staffed, but then I also heard perhaps it may have been a qualifier around a hiring freeze. So I just want to understand, when you say you're fully staffed, are you fully staffed at levels sort of pre-hiring freeze, or are you fully staffed within the limits you're authorized under this current hiring freeze?
No, I think we're fully staffed, I think it's fair to say. We've had to work, one impediment towards achieving that has been the hiring freeze. But I think we're about 160 employees. There's always a certain amount of vacancy in an organization of that size, but we've certainly made significant progress from where we were with the 25 vacancies, many of which were in important leadership, division leaders, assistant division leaders, and so forth. So we have some vacancy, but the point I'd make on the hiring freeze is that that's a process in state government that requires us to justify filling a position relative to the COVID response. So we have to have a specific rationale for filling the position. I guess we're fortunate in that regard that most of the agency's work is directly related to the COVID response, so it hasn't been hard for us to justify filling positions in the context of the hiring freeze.
Okay.
Thank you. Thank you, Mr. Secretary. And so, board, we're 15 minutes ahead of schedule, which is great because we're going to need this time later. So we've scheduled a break. You barely need it, I'm sure, but it's scheduled here. So let's go ahead with that. And that would, I would ask you to be back in 10 minutes. That is 9:25 sharp, and we will get underway. Maureen, will you please check to make sure that Megan Roy, Emily Simmons, and Mill Moore are standing by? So
Yes, I will do that.
please all return at 9:25 sharp. Thank you so much. And there are two parts to this item. But let me just set for you the context of all of this, because it's very easy to get lost and confused here. We're going to be hearing shortly from Kim Gleason and the committee that is working on final revisions to our proposed rules with regard to 1300 and 2360, which are the ones about census-based funding and modifications in practice. Those are rule proposed changes that arose during the public comment period on that legislation. What we are hearing in this section, and we will hear from Kim in agenda item J or H about that. Separately, Oliver and a committee of the board are looking at rule changes to Rule 2200, which changes would have nothing to do with the implementation of Act 173. Let me back up a little bit further. Act 173 directed the State Board of Education to propose and adopt new rules governing not only the census-based funding, which we're doing in 1300, and also the changes in practice, which we're doing in 2360, but also changes in rules governing independent schools, which is Rule Series 2220. And so what we're hearing today is the work of the advisory group on the 2220 rules, not on what Kim is going to be reporting to you, and not on what Oliver will be reporting to you, which has nothing to do with 173. And so just to clarify further for you, the rules in Act 173, which is the governing legislation and what drives us to be doing this work, there are 4 sections in Act 173 that are being addressed by the advisory group and separately by a working group that we will also hear from. Section 20 of 173 adds language about financial capacity and creates this provision for a visiting team, which those of you who've been on the board for a while remember we sent a visiting team to the Compass School about 1.5 years ago. And so the group is putting that legislation from Act 173 into rule. Second, 173 directs that essentially that approved independent schools that wish to receive public funding must accept any student, pretty much regardless of disability. There are some appropriate exceptions, but it's a big sea change for some of the independent schools. And it's a significant change in policy. And so you'll see rules that memorialize the legislature's intention in 20A. And Section 21 addresses rate setting, and we'll be hearing from Milmore and Emily Simmons about their work on that. And Section 22 requires a simplification of the approval process. And all of these sections are mandated by the General Assembly to be not only developed in rule, but there's a deadline for doing so. And the deadline reads that the board shall initiate rulemaking no later than 30 June of this year. Now, initiate rulemaking means a particular thing. It means that we go to the Interagency Committee on Administrative Rules and present a proposed rule adopted by the board. So in order to initiate rulemaking on the 30th of June, this board will have to have adopted a proposed rule, signed off on, committed ourselves to a proposed rule no later than our May meeting. So I just want everybody to understand that we need to get a hustle on here about getting these proposed rules settled and agreed upon. And you can see how long it's taken us on the 1300 and 2360. We've been working on that for nearly a year. These rules are not so complicated, but nonetheless, there will be controversy. And I want to stress that the May meeting is the last practical date at which the board can adopt these rules, because once they're adopted by the board, then there's administrative work to be done in memorializing all that, and then it must be submitted to ICAR not later than 30 June, and we don't know what time in June ICAR will be meeting. So that's just by way of putting everybody on notice that we are on a very short fuse here. With that much said, I want to introduce, for the first part of this discussion, which is all of the changes in Rule 2200 except rate setting. That's rate setting in Section 21. All other sections have been addressed by the advisory group. Speaking for the advisory group is its chair, Megan Roy, and also on behalf of the agency will be Emily Simmons. Later on, we'll then hear from Mill Moore and Emily Simmons about their work on rate setting. Megan Roy, are you ready to go?
I am, sure. Thanks, John.
Please give us an overview of what you have furnished to us. Board members, you should be seeing, have it in front of you, the proposed rule changes adopted by the advisory group. Megan, do you want to give us an overview of this?
I will also, and Emily, feel free to jump in. My intention isn't to do kind of a line by line of the changes. It's just to kind of summarize the conversation the advisory group had. And then if the board has questions, either Emily or myself, but probably Emily in terms of the detailed rules. But so feel free to jump in, Emily.
Yeah. Overview.
Yep. So the last time the advisory group discussed these 2200 series, so the minus the rate setting, as John said, was in December. Most issues by then had been resolved in the working group that had been meeting for the past months before then. There were three primary areas of discussion at the advisory group meeting on the 7th. One was related to enrollment of students on IEPs and ensuring that there wasn't a different process for students with disabilities. There was some discussion about the applicability or the particular applicability of this to choice towns, and some reordering and rephrasing of bullets that all had to do with sort of the process of enrollment. And what I would say is that there was discussion at the meeting and largely agreement in where the in the issues that were identified, and the group landed in agreement with the additional recommendation of having more working group discussion on the issue of rate setting, which I know you are going to get to. So that's how I would summarize the conversation. And Emily, I don't know, or John, is it instructive for the board to have more of a summary of those changes? I might look to you or Emily for that part.
Yeah, I think you might give sort of more detail about where the key change areas are.
prepared a slide for you all so you could have a visual that I could display if that would be helpful, John.
Thanks, Emily.
So are you seeing my slide
Yes,
deck? I just have two. So this first slide, and I should probably introduce myself, Emily Simmons, Agency of Education. These are the very high level requirements that come from the law, from Act 173. You have touched on all of them already, except for the last two bullets. This is maybe just by way of contrast. So you've discussed new requirements, which are applicable to independent schools that intend to accept public tuition. They're there in those two sub-bullets. There is the ability that a school may still apply to have the term approved, to be an approved independent school, but if it will not be interested in accepting public tuition, it need not meet the new special education requirements. So we'll sort of, Act 173 leaves open or sort of requires two versions of approved independent schools, those that intend to accept public tuition and those that do not. The rules deal with that through definitions. And then a final point that the requirements we've discussed so far are not applicable to therapeutic, the special purpose independent schools. However, those schools are central to the rate setting rules. So just to understand the full context, here are some highlighted draft amendments, rules that are renumbered, that are especially substantive to making these changes for enrolling all special education students. So I don't think I need to go through them in detail, but I believe this will be helpful as board members read through the rules themselves. I would recommend that you focus on these. Just to put a little more on that, I think we've done really good work in the definitions section. The terminology in the world of independent schools is so important because the status of an independent school governs what it must do and what it can receive in terms of funding. We've had to make some changes to the existing rules about approval to add these new special education considerations. And then, as Megan was just discussing, a lot happens in the new draft rule 2229. This is where the vast majority of big substantive changes take place. Those, I would draw your attention to point 2, staffing, point 3, a really robust list of assurances that an approved independent school must demonstrate, and then point 4, the procedure that the advisory group was very involved in writing to enroll a student who receives public funding who will attend an approved independent school.
Thank you, Emily. Oliver, I see your hand is up.
Yes, thank you, Mr. Chair. Emily, just for the benefit of everybody on the board, can you just provide a high-level explanation of the different types of independent schools we had prior to 173, and then, as you mentioned, there's sort of this additional category that's being introduced with this rulemaking process, and if you just provide a high-level summary and distinguish between those different categories.
So in Vermont, we refer to private schools as independent schools. That's sort of the first thing to understand. Independent schools are broken down into approved and recognized. And if I'd say recognized is the first level of state recognition, or certification is maybe a better word to use. If you're in a recognized, if you want to run a recognized school, you have to send the Agency of Education certain information about your school, like where it is and how many students you have, and that you comply with state public accommodations and fire safety sort of requirements, but not to the level of following education or curriculum requirements. We have recognized schools so that the state can know where students are attending and know that they are not truant, right? So you can, what you get as a parent for sending your student to a recognized school is that they meet the mandatory enrollment requirements of state law. Then you have approved independent schools that the board is more familiar with, that schools make an application under Rule 2200, demonstrate that they meet all the board's requirements, and have the status approved. All approved independent schools pre-Act 173 are eligible to receive public funding on behalf of students who live in the district, that rather than operating a school, they pay tuition for one or more grades. Post Act 173, within the world of approved independent schools, the legislature asked us to put new requirements on schools that will receive public funding.
Sorry to interrupt, Emily. We're getting a lot more background noise. Maureen or Suzanne, if you could.
I'm muting as fast as I can. People are coming on. So thank you.
So in the Act 173 world, look at all the approved independent schools. Tell approved independent schools, if you would like to receive public funding, there's some new requirements to ensure that you're able to enroll any student, including those who have an IEP and who are placed there by their supervisory union as an appropriate special education placement. So the General Assembly in Act 173 did not give a new term. It's just approved independent schools, or approved independent schools that intend to receive public funding. And it's that latter group that are doing new jobs in terms of special education.
So, yeah, go ahead, Oliver. Oliver, do you have another comment? Okay. Thank you for that. So, board, if you haven't already, I encourage you to spend some time reading through these proposed changes to our rules. They are, so far as I'm able to see, all responding to the mandates. Everything you see here responds to the mandates of Act 173, which were quite prescriptive. Normally, statute is very general and requires a great deal of rule interpretation to turn it into actionable language for schools and administrators. But in this case, Act 173, the General Assembly wanted to get it exactly the way they wanted it to be, and so they were quite prescriptive. And so the rule changes have a great deal of guidance for them. In some ways, that makes it easier. I would just, a question for Megan and Emily. I'm working from your 17-page piece, and in some cases, I feel that the rule that you are striking through or amending is not our existing rule. And I wonder if it's an earlier version of the rule as you had changed it that you subsequently changed. For example, you don't have to figure this out today, but I bring it to your attention. On page 8 of 17, middle of the page, there's a section called Section 2.2, used to be 7, it's now 8. Length of approval. And then below that is 2228.1, and it's all struck through. It's called revocation, and it's all struck through as if it's in present rule and is being eliminated. But I do not find a 228.1 called revocation in our present rules. And so typically, as you know, when you are proposing to modify a rule or a law, you strike through and add to the existing version of that rule. Do you have an easy explanation for this, or is this, please?
Yes, that's because where you're looking at a Microsoft Word's markup, track changes document, and you're exactly right. That's language that has been moved within the work of making amendments, not directly to the underlying language. This is not the format that you'll see as the comprehensive proposed rule that the agency will provide to the board. This is more fairly described as a working draft, a draft that is actively being
Thank you.
amended.
Thank you. I'll be eager to see that version, because it's difficult to be working from an interim version as a point of reference. Yes, Megan, you wish to speak?
Well, just very briefly to tag on to what Emily said, I do think that makes it challenging to see maybe with the document you're looking at, but it is indicative of good work by this working group, because there was an open opportunity to look at existing language, look at a first draft of new language, and then give input to that drafted language. So while I understand that it may be confusing, I just want to say that it is indicative of what, and others who sat on that group can certainly weigh in, but by and large was a healthy working process.
Boy, I'll say I'm astonished at the level of attention to detail that you and your group and the agency and the visa folks all reached consensus on. This makes rulemaking look like a walk in the park compared to 1300 and 2360. So you've done, you've moved the ball down the field very far, very fast. Kathy Lavoie, you have comment or question?
Yes. Hello, board. I had a question regarding, John, you had referenced how prescriptive the legislative body was in what they wanted done in this set of rules, but do you think maybe this is for the secretary, the confusion? It strikes me odd that they would be so prescriptive and then not identify the two different levels through a name of an approved independent school, and how much confusion that might cause, not so much for the school itself, of course, but for parents that just look to see an approved school.
That's a great question, and it's one I had myself. And while Emily is of course accurate in saying that the legislature directed that there be a clear differentiation between these two kinds of schools, they did not prescribe the titles to be associated with them. And my first reading of this, that immediately jumped out to me also, that there is a possible element of confusion created by something called an approved school, and then an approved school ineligible to receive tuition payments. And I am going to propose to you that that this and a few other small, if you will, perceptual details need to be addressed and perhaps improved. This is in no way a criticism of the advisory group or the agency. I think you've done terrific work. But as that jumped out to you, kind of a layperson, and to me as a layperson, I do think we need to see if that can be sharpened up. In effect, this creates a fourth category of, or at least a third category of schools, maybe a fourth, and yet the language is confusing. I am going to suggest to the board that, and I've already talked with the chair of our subcommittee on Rule Series 2200, which group, to be very, very clear, is not working on rules associated with Act 173, but on other possible changes to Rule Series 2220. I'm going to ask that committee to take a break from their work on non-173 matters and take a look at this document with an eye toward any minor changes, not significant changes, any minor changes to the language that would be helpful. And they will come back to this board at its February meeting with their thoughts about that. And if at all possible, we would, Oliver, my hope is that you could get your recommendations done well in advance of the February meeting so that they can be sent to Megan and the advisory group and to Emily and the agency so that they're able to give us their thoughts about those suggested changes at the February meeting. So, Oliver, this would place a little burden on you and your committee to kind of jump on this, but I'm sure that in the space of one meeting, you can sort through any recommendations that you might have for essentially fine-tuning the language here. So that is what I think you've done terrific work. I think Mil Moore in his comment in response to my email expressed almost amazement at how well you had all come to a consensus on this language, and I do commend you on the work you have done. I think there's yes, Oliver.
Yeah, Mr. Chair, I'm happy for my committee to take this little bit of fine tuning on, but I'm a little wary since the working group has spent so much time in this. It might be better for them to address it, because I think by the time we get our head wrapped around it, it's just going to be inefficient. And I want to be really careful that we don't interfere with their work, if that makes sense.
Understood. I simply wanted to get the perspective of people who are knowledgeable about 2220 and how it works generally, to make observations such as the one that Kathy did, which is the language about what these categories is. That language is possibly very confusing to the public. A school can call itself, we are an approved independent school, and then mumble, but we're ineligible to accept tuition. You know, that's just an awkwardness that I'd be delighted if we could come up with another term for one or the other of these categories.
And perhaps
if you want to be in touch with Emily and Megan as a committee, that's great. I'm happy to, I mean, they've done such great work. I'm delighted to have consultation going on. I'd like to you all to come back to the next meeting, having addressed the problem Kathy's identified and any other problems that you and your group might notice in the language. I'll give you an illustration, and this is not the fault of your working group. It's a legacy from the language as it's been for years and years, and now I'm not going to be able to find it. There's a point where it says that the secretary shall determine, yes, this is in 2223 dot your 4. The commissioner or the secretary shall designate a date for action by the board. Officials of the school shall be notified of this date. This is in connection with appeals of a determination by the secretary. As a general rule, Dan and I try not to be directing each other about what we do. And the designation of the date for action should be, the actual date for action should be by the board, not the secretary, because the board is solely responsible for its own agenda. So this is a small point, and this has been in statute in rule for a long time. It's no wonder that you didn't address it. But that would be the kind of thing, Oliver, that as a board member, you might notice that our colleagues on the advisory group did not. So let's leave it that this is terrific.
John, can you hear me? This is Peter.
Yes, Peter, welcome aboard.
Thank you. On page 4, on item D, it talks about the board forming a committee
That's existing statute.
Study committee, and I just questioned the resources. We've been through this before to do that.
Peter, that's existing statute that in late 2019, I think it was, we activated on that and formed a visiting committee to the Compass School. Mm-hmm. So yes, it was a challenge on resources, but we were able to do it, and frankly, I think it was a great success all around. That's existing.
Yeah, I'm just also reflecting on Kern Hatton and that situation also, but anyway, I'll let it lay.
Well, you raise a good point, and I would just remind the board that the board's counsel, in our review of the Kern Hatton matter, observed that the language in 173 is an anomaly in that it's the only place where the board is directed to be an investigative or visiting team. And classically in our statute, the board is only kind of quasi-judicial, and it functions in a review capacity, not an investigative capacity. And Oliver and his team are looking at this because this is a real anomaly and very questionable to the board as to whether we should be in the business of going and visiting independent schools. Traditionally, it's been the agency that's done that. They've come and reported to the board, made their recommendation, and the board acts upon what the agency has reported to us. This new language in 173 created a whole new responsibility for the board, which, apart from it being a resource challenge, is frankly a deep philosophical challenge as to is it appropriate for the board to be doing this kind of visiting and investigating stuff? And I think some of us think, no, we should probably go, but we can't change that. It's law. The only way that can be changed would be a recommendation to the General Assembly to make a modification to the language it adopted in 173. So, Kathy, your hand is still up, but I think you're probably okay. Let us now move on. Thank you, Megan. Thank you, Emily. And Megan, I hope you'll convey to your group how impressed we are with what you got done.
Thanks, John.
Thank you. I'd like now to move on to the second part of this discussion, which is the everything that Megan and Emily have talked to you about, everything that they've done on 220 and needs to be done on 2220, except rate setting. And we're now going to talk about rate setting. We have Mill Moore on board, I think. And of course we have Emily. So who wants to begin with that and tell us where you guys stand on that?
I'll just tell you that the advisory group's vote that it took to support this draft did not cover Rule 2232 and on. So that's where the work of the working group that Mill is a part of will be focused. When we say rate setting, what we're referring to is a process that the board has seen a little bit with the Mill School. So this is a process internal to the agency where we are charged by the rules to review the information submitted by therapeutic independent schools, as have also been called special purpose independent schools. These are the schools that enroll only students who require special education services and who are placed there by their supervisory union, including those supervisory unions that operate all grades. Right, so this is not a public tuition payment arrangement. This is just a need for special education in a particular setting that these therapeutic schools provide. So rather than getting their funding under the general tuition statutes, the average announced tuition rate, so forth, these schools' funding comes from a rate that is paid by the supervisory union and is approved, the maximum rate is approved by the Agency of Education. Those rates are required by the rule to be no more than what is reasonably related to the level of education services that are provided to students. That phrase, reasonably related, is about all we have in the current rule, and all parties agree that more information is needed in rule to govern what will or will not be allowed in a school's rate.
Very good. Thank you for that overview. Mill Moore, do you wish to comment?
Yes, thank you. Good morning, everybody, and thank you, Mr. Chairman. So the rule...
Mill, your audio is not very clear. You might need to turn off your video to get a little more bandwidth.
Okay, we'll see if this works any better. Yeah,
it does.
I think it will be.
Thank you.
So in our opinion, this rule about rate setting relates to two things of importance. One is the agency's responsibility to approve tuition and excess cost rates for services provided in schools, and to do that with transparency, consistency, and accountability. And second, it's about a somewhat overlooked part in the statute and rules. The agency has a responsibility to advise and consult with the independent schools community about the nature and amount of services that are needed throughout the state. And I think the agency also has a responsibility to set rates in a way that makes it possible for schools to thrive. That is, to be fiscally strong and to deliver services consistent with evolving best practices. In my view, many of these independent schools doing only special ed struggle to provide professional development in their schools. They struggle with their capital expenses. There's a lot of places where they need better support. So we need to talk about those things in the rate setting context. And of course, all of this is very complicated. Anytime you're talking about making changes in policies and procedures, and of course, a lot of money is at stake, and that always makes things complicated. This is extremely important to independent schools as well, because this is a once-in-a-generation opportunity to review these rules and make essential updates. As I mentioned to you in my email, Mr. Chairman, it was astonishing how easily things went in the rest of the rulemaking. I hope that agreeable climate prevails with our opposite numbers in the other stakeholder groups and with the agency. If it does, we should be able to resolve all of these needs.
Very good. Board, you'll remember that you received an appeal from the Mill School some time ago about rate setting. And in the end, the board did not have to become actively involved in that because the parties reached agreement. But you can see that rate setting is very important, both to the state and to the LEAs and the districts that are sending children to these schools, but also to the schools themselves. Just for clarification, who is it who is navigating together this toward these new rules?
It's the agency convening, members appointed by VISA and by VCSEA.
Okay. How many people are involved?
8.
Well,
the Council of Independent Schools is also represented.
Yes, Emily mentioned that. Yes.
Yes.
So, oh, pardon me. She said Visa and also the council. Oh my. Okay.
Yes, and the Special Ed Administrators Group.
Okay. Thank you. Sounds like a big group. So, let me just remind you. I want there to be no confusion about this. The board, by statute, must adopt a rule and present it to ICAR not later than the 30th of June. So just be forewarned, the board will insist on this. So you need to really, really be moving on this, because you can't just show up at the June meeting and say, here it is, and think the board is going to sign off on it. The board does not want to be put in that position. The latest that you can do here it is at the May meeting of the board. And so that means you need to have all of your stakeholders and everybody involved, the agency and all of the stakeholders need to be signed off on a document that the board can then act upon at the mid-May meeting of the board. So that's, I think, a long reach in a short time. Do you have any comment on those instructions?
We rely on the Agency of Education to convene the meetings and start with a draft set of proposals to which we will respond. We're ready to go.
Emily, do you have any thoughts?
No, I hear you loud and clear.
Thank you, Emily. All right, then. Go forth and do good work fast. Thank you very much, both of you, all of you. I think we can move on to the next topic, which is item H. Now, board, again, there's so many things moving here. I just want to help you be sure you know where you are now. You're now sort of stepping backward in time to the 1300 and 2360 rules, which the board adopted a year ago and began the rulemaking process when it adopted it, the draft proposal. You'll recall we then took that to ICAR and went through the whole process. We're in the thick still of the APA process, Administrative Procedures Act process with 1300 and 2360. In that process, there is a stipulated requirement that there be a public comment period, and there was in May. And we realized, however, and we were advised, I think very wisely, that we needed to extend that public comment period because it was so hard for advocates and parents of special needs children to be able to comment to us. I mean, parents were just underwater at that point with demands and needs of their children at that time. So we extended the comment period until the end of December of this past year, the longest comment period probably ever in the history of rulemaking. And it was very productive, and we got a terrific amount of additional input. And Kim and her committee have been working to sort through that additional input and see how, if at all, it should modify the rule that the board had proposed back in February, and that is in the ICAR process. Within a month or two, or at most 3, we need to go back to ICAR with the final rule. And it goes not to, I'm sorry, ICAR, it goes to something called LCAR. I'm sorry for all these acronyms. LCAR stands for Legislative Committee on Administrative Rules. And the sequence of events is that once you've received public comment, you can make changes to your proposed rule, the one we adopted in February of last year. And then you present your final rule to the Legislative Committee on Administrative Rules, and you submit a copy to the Secretary of State. LCAR reviews the final rule, gives its approval or comments, and it goes into effect. So we're at the stage now where we're trying to wrap up our interpretation and application of the public comments we have received and ascertain how, if at all, they should modify the draft, the proposed rule that the board adopted in February, which, by the way, in turn came after over a year of work by the advisory group and the agency and stakeholders. So with that context, Kim, we're eager to hear from you and your committee.
Thank you. So we've been hard at work, and we've thankfully had tremendous support and collaboration with many. So just to outline sort of where we've been, we began at the end of November. We looked at all of the public comment we had received. We were charged with looking at the areas that had received the most public comment, and that was around adverse effect, parental consent, and MTSS. And in doing that, we, at our first meeting at the end of November, took the opportunity to look at what we had received and craft our questions that needed clarification so that we could send those back out and ask for support. We did that and sent our questions to Megan, to Marilyn, to Jackie, and to Emily. And thankfully, they provided their responses to those questions and continue to be patient with the fact that we recognize how technical this material is and how regulated special education is. And I think our overarching ideal was to, if we were going to propose modifications to the language, that it is improving alignment with federal regulations, that it is improving consistency and aligning with best practice. So those were areas that we felt would be worth making movement. And interestingly, in receiving feedback from Jackie, Marilyn, and Megan, there were many areas of consensus, and that was helpful to see, or at least similarities in the vein of their responses that allowed for subsequent conversations and the offer of those folks to meet with us in a working group meeting. So we met in December and discussed the feedback we had received from the stakeholders in giving us responses to our questions, and then scheduled with them for January 5th, where we had the opportunity in more of a working group format to hear their thoughts and come out of that with a request for Emily to draft language capturing those conversations. She shared that out with Marilyn and Megan, and I think had crafted it with the collaboration of Jackie Kelleher, and that is a draft that those parties have also provided feedback on, and is, I think, wisely looking for us, as we've made some movement, to convene another meeting. So we are hopefully scheduling for next Wednesday, and just looking to refine the timing so we don't conflict with their other meetings. The long and the short of it is we won't have final draft language for you today. We will by the February meeting. And the overarching movement, and I don't know, Emily, if you want to characterize it, I was going to go through your big points from the email when you shared the draft with us, but you having authored that, I'm wondering if you want to bring us through the larger areas of movement that you incorporated into the draft, knowing that we don't have full, not all of it is consensus at this point.
Sure. Yeah, I can make this as high level as board members want. Just to start, the 3 areas where it seemed that we would be able to find common language are around the way the rules currently define adverse effect, the method for identifying 2 disability categories, that's specific learning disability and deafblind, related to adverse effect. There's a connection there. And then finally, around how parents might have a more formal method of giving their feedback about the IEP or the IEP writing process. So we are not there yet on 2 of those ideas. The draft does reflect what might be common final language, maybe needs a polish on the idea, the second point that I made, how to identify specific learning disability, and moving away from the discrepancy model. That's really in alignment with federal law, as Kim mentioned. So I would say, I'll go out on a limb and say we're very close on all of those. The third issue, I'm not sure if we're going to have a consensus, but I'm very encouraged that we, with one more meeting, will get words on a page that could be final for, for the committee to sign off on or not.
And I'll just add, with respect to MTSS, the 2 areas, broad areas that Emily mentioned, are adverse effect and parental consent. Our third charge was around MTSS, and there is consensus that will have a reference in this, in the 2360 series, but a rule regarding MTSS, I think, has broad consensus may be helpful, but it does not belong in 2360. It would be an entirely separate process. It sounds as though there's some initial thinking and work happening in that regard, and those equipped to forward those ideas in writing and begin a separate process are invited to do so. We would not be the impetus for that, but it seems as though many have thought long and hard about it and recognize it doesn't belong in 2360 more broadly.
Very good. Just so we've taken one of the 3 topics off the table, but it's on a new table, and I want to just ask folks who are interested in the MTSS becoming rule, not just a reference to it, but actually incorporated into rule, to come back to the board very soon with a proposal for what that new rule will be. What is it affiliated with an existing rule as an addendum to an existing rule, or is it a new standalone rule? What the language for this will be, so that we can begin a new rulemaking process that incorporates MTSS. That's how this is going to have to go. If you want it to be rule, we're going to have to start a new rule or amend an existing rule. And as you can see, this is all very time consuming. And so I would urge folks who are interested in this to come back to the chair with a proposal for where this would go and who would be involved in drafting the language. So back to the two topics that are enormous, and you've done a terrific amount of work. I thank Emily and the stakeholders, Marilyn Mahusky and others, and Kim and you and Jenna and Bill and Angelita on the committee. We received, in addition to the draft that you gave to us on 2362, we received from Marilyn Mahusky a side-by-side. And you all, I wonder if had a chance to see this. What does the committee have to say about the side-by-side, and how does it kind of relate to the draft that the committee sent to us?
Unfortunately, we had received the side-by-side after we met on Monday. And so from a format standpoint, we had previously received Marilyn's feedback, so we were able to consider that. And I think Megan had provided her feedback in a similar format to that side-by-side notion. That is a very helpful construct for looking at the information. I think in the time frame to turn around a draft for you to see even a first blush where we had some language and some consensus and comments in the margins around sort of where those things differ, there was no opportunity to really incorporate that version at that point. And frankly, working around really tight timeframes just in general, and with very busy people who are committing a tremendous amount of time. So very, very grateful to have received it in that context. I think it will help inform all of it, because I think important to note that was a similar format that we received Megan's comments as well. So we can pull all that together with the draft in our working group meeting when we meet on Wednesday next week.
Thank you. Thank you. Yeah.
Thank you to Marilyn and Megan and Jackie and Emily. This, like I said, incredibly complicated work. And I continue to lean in and learn. I am not from an education background, and I am really, really grateful for the patience I'm sure it's taking on their part to keep us in understanding and moving this work forward on behalf of the students and families, and also recognizing the professional expertise of these folks who are committed to this as their life's work. So I am just beyond grateful.
Yeah, I share your sentiment. The stuff makes my head hurt. It's so complicated, and it's so foreign to a layperson such as myself. I did skim through the side-by-side, and I do think these side-by-sides are awfully helpful for us lay people to see kind of what the existing statute is, what the recommendation of the majority of the stakeholders or agency is, and then any other further details. There's something that sort of confused or makes me question is in both the kind of consensus view and the commentary of the Disability Law Project, there's language about there being choosing between a scientific research-based intervention or to use a model based on other alternative research-based procedures for determining so and so and so on. And I see this in a couple places where the rule would give practitioners in the field, I suppose LEA folks, a choice about the sort of intellectual methodology that they would use for making evaluations. As a general rule in improvement practice, the practice of continuous improvement, a general principle is that there is one best way. And sure, there are lots of alternatives, but there is one that is best practice. And that is and in order to drive improvement, everybody does it the same way. What is the rationale for giving these choices in method of analysis? Yes, Emily has a response.
It's what the federal regulation says, word for word.
Silly me. Thank you. Really?
And I will just appreciate that to the extent similar to the definition of special ed, finding language that we can reference in federal law, I think is really helpful and important. And I think providing opportunity for improved practice that can incorporate professional expertise and judgment is important. I think, and maybe it's helpful to know with Jackie's background and that some of the modifications in the draft, Emily was able to look to models from, I believe, Connecticut and maybe Maine and New Hampshire to just look at language that is being operationalized and how so that some of the intentions of our old rules were to create sort of tight guidelines that allowed for consistency. And a great deal of what we heard was that just isn't happening in practice. So it is the pause. Let's recognize that the intention of this is not necessarily happening in a way that is working for families and probably not even for LEAs. And so, or consistency as students might move from LEA to LEA. So if that were the intention and there's better practice since their original adoption, these rules are open. Let's see what we can do that makes the most sense. Recognizing, I think, and I heard loud and clear from Megan, there's not a resistance to affecting some changes. It's the importance of having the support to the field to make these changes and do so with fidelity. And I don't want to put words in your mouth, Megan, but that's the sentiment that I'm hearing, that there are acknowledgements that there are some problems with what was intended to have created consistency that just isn't. And those won't be resolved by removing the guardrails alone, and rather they will need support to implement with fidelity and better consistency and transparency. So did I get it? I'm watching you shake your head, Megan.
You did. Yes.
Yeah.
Yeah, thank you for that. And it touches upon something that we as board members have encountered in all of our years of service on the board is wide variation in practice across the state. In almost any dimension that you might want to look at, whether it's how physical education is done or how American history is taught or how rules and guidelines about special education are interpreted and implemented, there is enormous variation across the state in how that's done. And some districts and LEAs, perhaps the majority of them, are faithful and attentive to the guidance. And in many cases, quite cavalierly, the guidance is not attended to in all dimensions of public education in Vermont. And variation is the enemy of quality. There is a best practice, and to the extent that everybody in the system adheres to the best practice, to that extent, the quality improves. To the extent that there's deviation from quality, from best practice, there's deviation in quality. And you remember that Vermont is one of only 3 states which is under federal notice that the quality of some of the elements of its special education programs, some, is deficient. So anything you can do to put guardrails up in such a way that there is no choice in communities that are resistant to doing certain things, including how parents are treated. There are many districts that do a terrific job, but we've heard testimony that you can move your child from this district to that district and find they're treated in a totally different way. That can't be desirable. So I applaud you for clarifying the rules and also for tying as much as possible back to the federal regulations, because they actually are calling the shots on so much of this. And also, I applaud you for borrowing from best practices in other states, because other states seem to be doing as well or better than we are in their administration of special education.
Thanks, John. I think to foreshadow the thinking around parental consent, the move is to provide, I think, our interest is in seeing a way to capture parent feedback without interrupting the process or recommendations of those who have put together a thoughtful IEP plan that may be disruptive by picking and choosing as though it's a menu, which may happen in partial consent. So we, as a committee, we're not leaning towards changing, moving towards partial consent, but rather that the process itself be better directed to capture feedback from parents as partners in the process, parents, guardians as partners in the process, which would not necessarily necessitate a change in the IEP, but rather help inform how that, the parents understanding the process, if that is moved to a different special educator for the next time an IEP is crafted, there's captured sentiment by the parents. So that is the general sense of where we are leaning on parental consent. Better practice that falls short of a laundry list of requirements regarding planning or scheduling a meeting. I think from a practice standpoint, those that came through from the stakeholder groups were elements of really respectful meeting planning in general. So hopefully that is not necessarily needing to be in rule, but rather maybe may in fact already exist in a parent engagement kit that's offered from the AOE. So there may be tools out there already. There may be some opportunity to expand tools that are available to districts. But in terms of the rule, we did feel there was some importance to expecting that parents at least have a window of opportunity to have thought through their IEP meeting and offer their written feedback and have it be captured somewhere. So that is the direction we're leaning on parental consent. Just to foreshadow.
For you about that, we all heard frequently that New Hampshire has a parental consent process. I think, and even rules about period of time of notification and so forth. Do you have evidence that that process in New Hampshire produces the kind of problems that you describe would be likely if you had parental consent? Or is that merely the speculation of stakeholders here in the state?
I don't think we sought out or requested proof necessarily. I think I think we felt there needed to be improvement in practice, but that partial consent on an IEP, I did not hear that being it may in fact be the ideal of those from the Disability Law Project, and again, Marilyn, I know you're on, I don't want to put words in anybody's mouth. There was a compromise suggestion that the rules include a form and some very specific list of requirements for meeting planning and scheduling. And I think we thought the spirit of that was important, and how you go about that in rule seemed that this notion of adapting a form to capture feedback is a compromise there as well. So we pivoted away from the idea of partial consent, recognizing the challenges with that, as the LEA is obliged to be delivering the services, and they are crafting their IEP based on professional expertise, the data they have to drive their decision making, and had, I think, very legitimate concerns that having parents pick and choose might disrupt the package of services that they feel are important for the student. So that was where we leaned away from partial consent.
Those concerns seem to be speculative, where you have available to you a state right next door that apparently has been practicing parental consent, and they could tell you if the kind of disruptions that is being imagined by the stakeholders you're talking to, in fact, materialize or not. I think the other things about, how much notice do you give parents and that sort of stuff, I can understand the desire not to be prescriptive. On the other hand, there's simply no doubt from the range of parental testimony that we got that there are a fair number of instances where parents are not treated with respect and accommodation. And that variation ought to be regarded as unacceptable. So if it takes rules specifying the periods of notice and sort of the norms of respectful behavior, the ones that we, by the way, practice on this board, where people are given adequate notice, all documents are public, and so on and so forth, we live by a series of norms that allows us to be constructive with one another and to give everyone an equal opportunity to speak. It seems that in some cases, local LEAs are not respecting those norms. And that is what's making some parents unhappy. And I think if any of us were in their shoes, we would feel the same. So I guess I'm just, as a lay person who's involved in a lot of public consultation, yeah, it makes it more complicated. And yeah, these voices need to be at the table. So I hope we can get outside our own, I think, essentially provincial understanding of these matters and ask others in other states, how's it worked out? And if they have the problems that's being imagined, well, good, fine, then we're informed. But if in fact they find that these major roadblocks created by parental consent or engagement don't in fact materialize to any appreciable extent, that's news that we need to take into account, I would suggest. But I'm speaking too much. I apologize. Board members, do you have any comments or questions?
I think Marilyn has her hand up.
I see that. I want to give the board members an opportunity to pipe up here, and then I will get to Marilyn Mahusky. Board members, any comments or questions? Marilyn Mahusky.
I see Bill. I'm sorry. I see Bill's hand now.
Wait.
Okay. Alphonse Gaston. So Marilyn, you go ahead, and then we'll hear from you, Bill.
Yeah, thank you. Good morning. I wanted to just sort of, to some degree, answer the question that you just asked, John, about feedback from other states. So relative to the parent notification, I wanted to say a couple of things. One is that the recommendations that I put in my side and side were informed by the consensus from the Special Ed Advisory Panel. So I took that language from the comments that the special ed advisory panel gave to the board in November. So that's one thing. And it's a little bit different than what the agency proposed, in that there's no requirement that the LEA actually do something with parental feedback. So I think it's fair to say that there are some times that you have parents that no matter what you do, you are not going to make them happy. So we're not adding a burden onto the LEA to continue to meet and continue to meet to continue to meet and address the same issues over and over and over again. But what it does do is it allows the LEA, to schedule another meeting. So there may be legitimate reasons. And that is the model that they use in New Hampshire. And it is my understanding from practitioners in New Hampshire, and I would actually be willing to follow up with our counterparts in New Hampshire, that it works well in New Hampshire, that it is an avenue for parents to give feedback, and that's valuable. Because oftentimes there are some issues where there's agreement and there are issues where there's disagreement. So that by giving some sort of opportunity for parents to give written comment, it's a valuable process. The other thing I wanted to say relative to how other states practice is I did have a conversation with my counterparts in Maine about the adverse effect eligibility process. And what they said is that eligibility is almost a non-issue in Maine, is that it works really well. So I wanted to compliment the agency for sort of looking at some of the other states and finding a process that appears to work well in that state in determining in how they consider adverse effect. So I think that was, I thought that was really helpful. So, and I also, in my side-by-side, took into account sort of the comments of VCSEA, which is that we felt it was really important not to leave the form that the agency was proposing. So they proposed a main form. Again, I edited it, which you now all have, so that we can look at and see and try to incorporate Vermont practice, taking into account how we do things in Vermont that we want to continue to, that we value and we want to continue to operationalize, but we use the main form to do that. So I wanted to just say that there, I agree with you. I think it's important that if there are other states who are doing this well, we ought to hear about that and try to incorporate that, and being mindful of the fact that we do practice things a little bit differently, and some of that is good and some of that is not so good, as we've heard from some of the criticism in the public comment.
Thank you.
Thank you.
Bill Mathis, you had a comment or question?
Just a quick comment. I look at this with a little bit of caution, in that there are any number of fields of thought in special education. They don't always agree with each other. Sometimes the technique will work well with one student, but not with another. And that's why they call for individual educational plans, because they are individual. So my only caution here is that we remember that this is a very fluid area. The research is not really hard and fast, and applies to all kids in all situations.
Thank you, Bill. Thank you very much. Just thinking about the schedule ahead. First of all, I want to say again, I'm very, very grateful to Megan and her group, and Emily, and certainly to you, Kim, and your committee, and other stakeholders, Marilyn and Ms. Kelleher and others. I know you put a ton into this, and I'm very grateful to you for that. I think the whole state should be grateful to you for that. So you have some time to get this the way you want it to be. If thinking ahead, if you were able to bring us a final proposal for action in March, I think we'd be okay, because as Emily can tell you, we've made application to LCAR, the Legislative Committee on Administrative Rules, for an extension of our time period for processing all this public feedback. I think on the 4th of February, I will have to testify in front of the LCAR people and explain why we need this extension. And the feedback Emily gets is it's extremely likely that we will be granted this extension. the extension is because, well, I don't need to go into it, but we need one, and we're probably going to get it. And that means that you, I think, we probably could even make our final approval as late as April and still be within the window that LCAR is likely to grant to us. My encouragement to you would be, do your best to come back with kind of a consensus document, ideally a side-by-side or whatever method of presentation you think is most persuasive at the February meeting. Then come back at the March meeting with a document that is a markup strike-through that's classic, that the board can then act upon. And by the way, we'll need to see the entirety of 1300 and 2360, not just where you're changing, but the entire docket rules, because we are now saying these are our rules that we are presenting to LCAR and will go into effect. So when you present us that document, we have to see everything we're signing up for. And if you can do that by March, that would be great. If things get off track and we have to go till April, okay, but we have to see the thing well in advance of the meeting, you know, so that we've studied and understand it. And then we have to devote a conscientious period of time for the board to be satisfied with the document that it is putting its name to, just as we did in February, you'll recall, with 132360. So, yes, Madam Chair.
Thanks, John. I was just wanting to clarify, our original thought, as Emily and I had talked about it, and hopefully after our working group meeting on Wednesday, that we would be in a position that at the February meeting, we might have that marked up language with a side-by-side to sort of point out where those changes are. Right. And that would be the first look the board would get at that. If we are solid with our recommendation and the board is comfortable with that recommendation, we would, and I'm going to hope I get this right, Emily, be able to direct the agency, Emily, to put those changes into the full draft, and whatever turnaround time would be necessary thereafter, we would be seeing everything as you're requesting in March that incorporates those recommendations in that draft language. And so I think we're saying the same thing. And then I don't know whether or not March is an action item, voting on the final draft that goes to LCAR, or if you're suggesting we would look at that and it would be more of a consent agenda item in April.
Well, it's hard to say at this moment, but if it's possible for the agency to turn around the final complete document 10 days before the March meeting so that there's adequate time for the board to study and the public, great. If the mechanics of that are just so onerous, and they may well be, then we would just see a quick and dirty version of it 2 or 3 days before the March meeting. We would probably say, this is great, but we can't sign off on it because there's not an adequate public notice. And, you know, at the March meeting, there might be some minor suggestions by board members, but they would certainly need to be in the realm of minor, so that it's very, very clear to you and to the agency precisely what is the final document to be presented in April. And if we can do it that way, we'll be golden.
Yep. And if we are in a position of real clarity and as much consensus as possible come the February meeting, I would suspect that turning that will be, I'm not going to speak for Emily, but I think that the changes and getting adequate notice to the board for the February meeting with our draft and recommendation is, we know what the time frame is for that target. And I know that it may be tighter than getting from February to March, because hopefully where we are with the work is going to be hopefully the last of our heavy lifts come next Wednesday. And then the rest of it is Emily's heavy list.
Okay, thank you. We need to move on unless there's a burning share on this topic. Thank you all for the very considerable work you've done. You're very close to the goal line, and this will be a huge achievement. Thank you all. I'd like now to turn to item J, which would be an update from the Working Committee on non-Act 173 rules changes in 2220, pardon me. And Oliver, if you're able to complete your work in less time than budgeted, so much the better, because we'd like to get started as early as we can on something else. Thank you. Go ahead.
Absolutely. Thank you, Mr. Chair. I'll keep this very brief. The committee has had a couple of very productive discussions. We've made some outreach to various stakeholder groups, and fortunately, we've had pretty good participation from a few of the key stakeholders, namely the Independent Schools Association, the School Boards Association, and the Superintendents Association. And I'm going to ask my colleagues on the committee to chime in here if I've missed anything or misspoken in any way. But at this point, I think we've sort of narrowed our obviously, as you pointed out, the scope of our work is narrowly focused on all things not directly impacted by 173. And where we've landed is, as has been sort of discussed in a prior meeting, is we're approaching this in two phases. So phase one are those things where we feel, that are essentially quick wins, things that we think we can get across the finish line, come back to the board with a full recommendation on in time to sort of insert into the rulemaking process that is dictated by the schedule laid out in 173. So we're looking, that initial phase is really focused on those areas where, we think we can find some consensus fairly quickly. And then those issues that will likely require more time, we're sort of pushing into phase two that we will take up as a rulemaking process likely to be independent of 173. So I think at this point, it's fair to say we've narrowed our focus into two areas. The first, most immediate one that we're hopeful we can sort of get across the finish line for this initial phase one activity is sort of cleaning up the rules around the complaint process as it relates to independent schools. And one of the things that sort of we've talked about is, we have a very binary process today where there's an allegation made, there's a complaint process, and then we go from 0 to 60 in 2 seconds. It's essentially, if there's a complaint, the only real sort of resolution, if you will, is at the discretion of the secretary bringing a formal recommendation to the full State Board of Education for suspension or revocation. And there's really no sort of graduation in between. So with it was actually Emily Simmons brought forth a really good suggestion, which is that we should perhaps have a more graduated scheme sort of to deal with intermediary sort of issues or sort of misdemeanors, if you will. So we've had a lot of discussion about that, and I think we're trending in a really good direction. Along those lines, we've had some discussion around the need for some greater transparency about what's happening with complaints. Sort of statistically, I think there's a discussion to be had around just publishing statistics on the number of complaints received, the disposition of those complaints, et cetera. But there's further discussion to be had at what point in the process do we actually want to provide a little bit more transparency around what a resolution may have been. So, for example, if there's some, relatively minor infractions that result in a, some technical assistance or some remedial action that can be followed up on and resolved pretty efficiently. Is that the sort of thing that we want to sort of publicize with publicly facing material? There's sort of another sort of step beyond that, which is where a school could be placed in probationary status. At that point, should that be made public? And then as we move sort of further down the scale, more serious issues that require or would dictate that the secretary make a more formal recommendation along the lines of suspension or revocation, how we handle those things. So lots of good discussion, more work to be done, but I'm hopeful that the various folks involved will be able to come to consensus and we can make a formal recommendation of the board. For phase 2, I think we've identified as a group some opportunity to look at the actual approval standards. That's a larger piece of work, and I don't think it would be reasonable to expect us to complete that in time to put that forward as part of the 173 process. Not saying it's impossible, but I think just given the timelines, that may not be achievable. But certainly something that we want to look at and intend to look at as a committee. And then as the sort of a final point, we've had some discussion, and I would suggest that we have a little bit more discussion later on in this meeting when we get to our legislative agenda. Mr. Chair, as you had alluded to previously, there is a bit of an oddity in 173 that, as has been opined by our legal counsel in the past, is a little incongruent with the APA process and just sort of, fundamental separation of segregation of duties with respect to investigations versus adjudication. So this is specifically the piece around reviewing concerns around financial capacity, a very narrow sliver. And there's this, sort of oddity within the statute that sort of puts us in the place of being the investigator, prosecutor, judge, and jury, which just is not consistent with sort of basic judicial norms, nor is it consistent with the APA process. So I think we'll want to have some discussion as a full board about making a recommendation to the legislature to more or less leave that intact, but just shift the duties, the investigative and prosecutorial duties, over to the Agency of Education, so that we can sort of look at things in a quasi-judicial manner without sort of having that conflict of duties.
Yes, no, and that makes perfect sense. And as you correctly observed, those are not. 173 was very, very specific in its language, and the rules that the advisory group has framed reflect that language precisely. So we can't tinker with that language until the legislature does, as you say. So that's something we would need to go back to them on. As you get into looking at what the advisory group did with 2200 rules, you'll see that they touch upon the conditions of approval. And there's good reason for that, because Act 173 directs us to simplify the approval process. And so they did some work to try to do so. You might piggyback onto what they're doing. They've made some changes in the conditions and approval process. I think you folks could probably be helpful to the advisory committee in strengthening that some in this review that I've asked you to do. Just simple and obvious things. For example, the conditions for approval are essentially described as what you have to have in your application, whereas they should be described as conditions for an approval of an application. So there's just language in the rules that is kind of clumsy. Another thing that's been brought to my attention by a former board member, and I think it's a good one, is that under the rule, we rely upon self-certification by boards of directors. A notarized letter from the board of directors is sufficient to validate that the school has the financial capacity it needs to operate. Well, that's good if you have a strong and capable board of directors, and it's meaningless if you don't. And so you might want to look at the reliability of the evidence that's presented for financial capacity. And you might be able to do some tinkering with that, some strengthening of that in the train that's on the tracks and leaving the station around the meeting in May. So if you can, you might jump on that.
One other thing I did want to highlight, and Jen Samuelson sort of brought to the committee's attention, and that is the sequencing of the rules themselves. The order in which they're presented makes it very confusing. The rules are already sort of challenging to read, but then when you add in sort of the fact that they are not presented in a logical order, it makes it very difficult to read. So I just want to highlight this for the benefit of the folks on the working group who may still be with us, that we're very likely to also make a recommendation that we reorder the flow of the rules so that they're just easier to consume.
And hopefully soon the agency and the advisory group will give us a draft of the rule changes that's based upon the existing rule, not on an intermediate version. Remember, we discussed that with Megan and Emily, and they intend to have that for us by the next meeting. If possible, if they could get it to you sooner, it would allow you and your committee to spot where the changes are needed much more readily, because right now it's a little hard to trace the lineage of the language you're seeing. Okay, is there anything else that you would like to discuss with us? I want to thank your committee. It's you and Kim Gleason and Jennifer Samuelson, and we thank you all and each for the work you're doing. And you'll be doing a lot more before long. So at this point, board, let me just jump to Maureen. Maureen, do you know if we have Ms. Acey standing by?
Yes, she is on this meeting and the executive session's running as well.
Great. So, board, we now need to go to executive session, and I will just make a general statement in public as to what that session is about. There have been filed with the board appeals by the parents of 4 children, 4 separate families with a child, each child has applied, or the parents have applied for tuition support to send that child to a religious affiliated school. And as is its authority, the local school district heard that request for tuition support, as is standard for anybody requesting tuition support. And they denied. And the parents in question, the 4 parents in question, have appealed that denial to the state board, as is their right under 16 VSA section 828, which says that an aggrieved party may appeal a decision about tuition to the State Board of Education, whose ruling on the matter shall be final, is, I think, the language of statute. And so now we have received these appeals, and now the board needs to figure out how we're going to go about responding to them in our quasi-judicial capacity. And for the purposes of figuring out the process that we wish to employ, we now intend to go into executive session with an attorney that has been retained by the board to advise us in this matter. We'll be speaking only about procedure and process, not the least about the merits of the case. Oliver, do you have a motion for us?
I do, Mr. Chair, and I'll just preface this by saying there's quite a bit that we need to go through to legally enter into executive session. And for clarity, I'm going to present actually two separate motions. The first motion will address the first requirement, which is that we need to, there needs to be a finding relative to why why executive session is appropriate. And then the second motion will actually address the procedure to go into executive session. So at this time, I will offer my first motion. So I move that the board finds that premature general public knowledge of confidential attorney-client communications made for the purpose of providing professional legal services to the body with respect to pending quasi-judicial proceedings and pending litigation to which the board is a party would clearly place the board at a substantial disadvantage.
It has been moved. Is there a second?
I'll second.
Yes, and Ms. Samuelson seconds the motion. I'm going to just divert for a moment. I see that there are two hands up, and I want to give each an opportunity. Dan French, your hand is up.
Thank you, Mr. Chair. I raised my hand just in terms of where the next motion is coming. So I don't have anything to say at this point.
Thank you. And Kathy, you had your hand up.
Yes, I need to let the board know that I'm not sure which case this is relative to.
Kathy, I think you can do this in executive session.
Okay.
We're not discussing merits of the case, we're discussing process only. Thank you. You can take your hands down. So it has been moved and seconded that the board makes a specific finding. Are you ready to vote on that question? Yes, question?
I just want to point out this does require a 2/3 majority.
Thank you. Thank you, Oliver. Are you ready for the question? Then we'll, Maureen, by call of the roll, please.
Bill Mathis?
Aye.
Jenna O'Farrell?
Aye.
Peter Peltz? Peter, are you on mute? We can come back to Peter. Kimberly Gleason?
Aye.
Sabina Brochu?
Aye.
Jennifer Samuelson?
Aye.
Kathy Lavoie?
Aye.
Oliver Olson?
Yes.
Peter Peltz, are you off mute or on the line? Chair Carroll, are you voting?
I'm voting in favor.
Thank you.
We clearly have a 2/3 majority saying, concurring with the motion. Oliver, your second motion, please.
Yes. At this time, I move that the board enter executive session for confidential attorney-client communications made for the purpose of providing professional legal services to the body with respect to pending quasi-judicial proceedings and pending litigation to which the board is a party pursuant to 1 VSA section 313 subsection A1E and A1F.
You've heard the motion. Is there a second?
Second.
Is there discussion? Hearing none. Yes, Dan French.
Yeah, I would just, Mr. Chair, say that I don't feel comfortable participating in this executive session, so I'm not going to do so due to our differences in our roles in this topic.
Understood. Thank you, Mr. Secretary. Is there further question or discussion? Hearing none, then Maureen, please call the roll.
Yes. Bill Mathis?
Aye.
Jenna O'Farrell?
Aye.
Peter Peltz? *6 to unmute, Peter.
I don't see Peter on the list.
Kimberly Gleason?
Yes.
Sabina Brochu?
Aye.
Jennifer Samuelson?
Aye.
Kathy Lavoie?
Aye.
Oliver Olson?
Yes.
And Chair Carroll?
Chair votes in the affirmative. The ayes have it. Now, you have agreed to go into executive session. Let me just talk to you about the mechanics of this. You have received from me last night, and I believe it's been sent to you again, but you can go to my email to you of last night and find a link to a separate team meeting in which we will conduct the executive session. The attorney will join us there. Any questions about that? All right, then please go to the link. Okay. By the way, did any of you get to hear the presentation by Amanda Gorman?
It's amazing.
Shattering. I just can't get over the brilliance of what she said and how she said it.
Mm-hmm. Amazing.
My wife did a little, as she's and Nan is quick to find out about people, and Amanda Gorman is 23 years old, grew up in LA. Her mom is a middle school teacher, yay, and she, by accident, went to Harvard College. Everybody has their own cross to bear, I guess, but she was wonderful. She was just spectacular. I hope we hear a lot more from her. So we're at a point where I think we certainly have a, what do you call it, Oliver? Not a colloquium, but
a quorum.
A quorum, thank you. I'm getting so old. And let us now entertain a motion. We're still in item K. We're back in public session. We're in item K. We've come out of executive session for anybody who's bothering to follow this. And the board would like to consider taking action as a result of what it learned from its attorney in executive session. Oliver?
Yes, thank you, Mr. Chair. At this time, I would move that the board designate its counsel, Bridget Assay, as a hearing officer to conduct pre-hearing conferences, set a briefing schedule, and handle other pre-hearing matters for the Dunn, Buckley, Gallo, and Valente appeals brought pursuant to 16 VSA 828.
Thank you, Oliver. Is there a second to that motion? I see a second. Kim Gleason seconds the motion. By the way, we have Maureen on board, don't we? Yeah, there you are. Yes. Maureen, would you call the roll, please?
Sorry, I couldn't unmute. Bill Mathis, I think he just got on.
Present.
Bill, we're voting on a motion to appoint Bridget Assay as the board's counsel to conduct a pre-hearing conference. So a vote in the affirmative is yes to appoint the attorney. So let's start with somebody else, please, and then come back to Bill.
Jenna O'Farrell?
Yes.
Peter Peltz? Kimberly Gleason?
Yes.
Sabina Brochu?
Yes.
Jennifer Samuelson?
Yes.
Kathy Lavoie?
Yes.
Oliver Olson?
Yes.
Chair Carroll?
Yes.
Bill Mathis?
I abstain.
Very good. The ayes appear to have it. The ayes do have it. You have voted to designate Bridget Assay as hearing officer to conduct pre-hearing conference. Thank you. That completes our work on item K. Let us now move on to item L, which is legislative agenda. In my introductory chair's report, I briefed you a little bit upon legislation that's already been proposed. Let me just give you a quick rundown of legislative issues that we either have talked about or probably have an interest in. Reform of the State Board, I outlined to you that there's pretty broad support for bringing that legislation back, getting it past both houses, and getting it signed by the governor. Unmerging. There seems to be nothing. You've received from Oliver a very cogent proposal. There seems to be nothing in the pipeline at the moment. And I'd like to come back to this and have a little discussion. Weighting study, clearly there's two pieces in the pipeline, one very broad and sweeping, implementing very quickly. The other, but in phases, but nonetheless, it's quite bold. And the other is essentially a study. Then there may be a proposal around the subject of data suppression. You'll recall the board has received complaints, concerns about what could broadly be called data suppression in a number of supervisory unions around the state. Dan, you may know something about this. State construction aid, do you know if there's been, am I right in thinking that nothing passed last year on that topic?
That's correct. I believe, particularly as COVID response sort of took over the deliberations, there was a conversation. I think the proposal was around doing a study, statewide analysis, and that sort of got into a conversation around HVAC relative to COVID.
Yes.
And then I think ultimately the bill was abandoned in favor of the COVID relief.
Right. And I think there's a piece maybe in the big bill that provides some funding that the agency will distribute in connection with HVAC improvements, if memory serves. But I think it's reasonable to expect that there will be some revival of legislation to either study or resume state aid to school construction. So let's just go back and talk about the unmerging topic. From what I've heard, there's at least one of the chairs of the committees has said that they might just put a moratorium on. And I think I'd like to ask the board, I'm going to be asked about this. I'd like to ask the board's views about doing something along the lines of what Oliver suggested, or about just simply putting a moratorium on and coming back to it later. Are there any views? Yes, Kim?
Do we have a sense if the moratorium would just be with the intention that it's sort of a stay until there's a session where it could be a priority?
That seems to be the idea, yeah.
Okay, as opposed to not at all being addressed. I'm sensitive to what I imagine are priorities of the time in the legislature right now. So if that were our only option, I'd be in favor of that.
Yeah. Jennifer?
Yes. I think that, Oliver has written a very compelling memo. I think it would probably require a lot of thoughtful consideration by the legislature to enact the changes. And considering the pandemic and other fires that might perhaps be burning brighter, it seems like a moratorium would be the best way to put a pause on things now until the legislature has the time and ability to thoughtfully address it. So I would be in favor of the moratorium.
Thank you. Oliver?
Yeah, I also support the concept of a moratorium. I think it provides a good sort of cooling off period, if you will, and provides the legislature some time to address this, as Jennifer highlighted, in a thoughtful manner. I would only suggest perhaps that that some preliminary work be undertaken in the first year. I'm always a little wary of this is obviously an issue not without some controversy, and I do worry pushing it into the second year of the biennium is an election year and typically makes these sorts of things a bit more challenging. I personally, I'd like to see some work begin on it, but I think it's something that could easily be started this legislative session and extend into the next session. So therefore, a moratorium actually helps provide that breathing room to allow for more thoughtful discussion.
Thank you. Any other views to convey to me about this? Had you go ahead.
John, can you hear me? This is Peter.
Yes, Peter, please go ahead.
I'm sorry, I just got back on. I wasn't able to access the tuition appeal. Has anybody talked about the tax commission that's been under study and seems to be gaining some legs?
We can come back to that. We're in the midst of talking about the unmerging of school districts. And the question before us is... I'm
sorry, I didn't pick up on that.
Yeah.
Thank you.
So we can bring that up later if you like.
Thank you.
Had you not expressed your views, I would have said, I guess I would argue a slightly different view. I think that a simple moratorium without anything more than that is kind of offensive to the communities who feel like they have a statutory authority, and they do, to disaggregate and sort of essentially without explanation, taking that authority away from them, it seems to me, is, well, it's a bit of a slap in the face to people who are complying with the law. One of the things I loved about Oliver's solution is that it proposes a set of criteria that ties this authority to the legislature's most recent thinking on the subject of school governance, as expressed in Act 46. And so it brings that old statute that's more than 20 years old up into today's world. The world is very different than when that statute was first created. There was nothing like the loss of students that we've endured in the last 20 years. So Oliver's proposal, I think, is attractive because it links that authority up to present-day values. And that has great virtue in that it gives people a way forward, but it sets for them some hurdles or conditions that have to be met. And that's to me always a more kind of democratic process than simply saying, well, we've decided you can't do that anymore. So I will, so if called upon to speak, I have the set of feelings that I have, but I have the views that you've expressed. So Oliver, you have some more comment?
Yeah, I want to be clear that what I've outlined in the paper, I still stand behind, and I think directionally that's, I would advocate that should be our recommendation to the legislature as sort of a final landing place. But to get there, I do think that it may require a bit of discussion in the legislature, and providing a moratorium ensures that there's a little bit of stability while the legislature can work through those considerations.
Yep. By the way, for practical purposes, I haven't checked rigorously, but I'm not sure that any of the districts that have voted to disaggregate have a clear path to doing so, because in every case that I can think of, it requires the consent of several other districts. And it appears that consent is not likely to be forthcoming in most cases. So even though there are a lot of people knocking on the door, I'm not so sure that many of them have the key to get in. Yes, Kim.
I think that notwithstanding, while the possibility remains for them, they would not be likely to be collaborating as part of their unified districts on the tasks at hand, whether that's preparing for implementation of Act 173 or any other initiative. And so I think a moratorium provides the space to come up with the appropriate guidelines, unless somehow that would move quickly. I really appreciated Oliver's recommendations. And I think that is more in line with the more current legislation that required unification, Act 46. So I think if there were efforts in that vein, I would say we support it. If there is anything between moratorium and that, I also support that. Standing in the way of anything other than the best we could hope for runs the risk of getting nothing and potentially communities becoming more divided in their efforts at a time where they have to be more united.
Yes, yes.
Sorry to interject, Mr. Chair, just a couple of procedural issues. The video for most everyone has disappeared, including you, Mr. Chair, and also Bridget just joined the meeting. I'm not sure that we need her for anything else, so I just wanted to call your attention to that.
Thank you. Bridget, AC, can you hear me?
Yes, I can. Apologies. I thought it was restarting at 1, but I must have had the wrong.
Yeah, it's all right. We have already conducted our vote, and you have been chosen to represent the board and conduct a pre-hearing conference.
Okay, thank you. I appreciate that, and I will connect with you offline too.
Very good.
For next steps. Okay.
Thank you so much for your help this morning, Bridget.
Thanks. Bye-bye.
Thank you. Thank you, Oliver, for the heads up. Are you missing video from all the rest of us, Oliver?
I see Dan and Bill Mathis, but no one else.
I think that may be a problem at your end.
Okay.
I think, raise your hand if you can see everybody else. Bill can. If Bill can, almost anybody can.
You can't see me. Peter here.
So
I can't see Jennifer.
Yeah, that's right. Well, I think maybe her camera's off.
Oh, okay. But my
camera's on.
Is it on? Oliver, mine did the same thing. Like I couldn't see anybody, and then I could see people one at a time. It just got kind of funky for me too. I tried a million different things.
Burdens on the network, probably.
For what it's worth, I've only ever been able to see the person who's talking. Like I can't see everyone.
I think that's the mode you're in.
Okay, I'll talk to Maureen maybe.
Yeah.
No, I had that same issue when I was using my school Chromebook. I only see one person, and now that I use my mom's like dual monitor setup, it's because it's a totally different like system. It works better. So I think it's the fact that like it was like a Chromebook versus now like a desktop setup. So
all right,
it might just be your computer, Jennifer.
Okay. So let's just keep trundling ahead. Thank you for that conversation about the waiting study. Bill, you have a question or comment? Bill, you're muted.
I would be not concerned, but I'd like to see Oliver's conditions, go over them closer. I think the opportunity to rethink things in light of the changing demographics of the state could be an added boon to looking at this again.
Thank you. So if asked...
John, this is Peter. Could I just voice about Oliver's statement and whatnot? I do think time is of the essence in regards to this these votes going on, and I would like to see something happen sooner than later. So if the moratorium is the easiest thing to do, that would be a stopgap from my standpoint. And the other thing, I know probably everybody knows this, but these districts, the votes aren't commingled. They're all voted on at district level separately, and that will, I think, make a big difference hopefully on the results. But so be it.
Okay, thank you, Peter. I'd like to move on in the time we have to now speak about. Let me just double up and say, so my intention when asked, I would bring this to the attention of the boards who asked me to come speak to them, that is to say the disaggregation, and I would share with them Oliver's draft and with the sort of commentary to the effect of if the committees feel that this could be implemented in this session, this would be the most desirable way to proceed. But if there's not an appetite for addressing this, then in that case, a moratorium would be the next best solution. So, okay, yes, that's all right. So let's move on now to speak about the weighting study. As I outlined to you earlier, Senator Bruce has introduced essentially a study, much of the work to be done by the agency, and to be completed, I think, by December. Whereas in stark contrast, Representative Sibilia and many others have sponsored legislation to start implementation in a sort of phased approach, but to get right to it. The recommendation we have from Bill is to commission a study by an outside committee of experts paid at what Bill's called commiserate rates, and I presume you meant commensurate with their professional expertise. My own take on this is that at this point, that idea is sort of moot. If there is to be a study, my own view would be that an internal study by the legislature or the agency that would have so much to do with implementation is far more influential than a study by a group of outside experts. And of course, the Sibilia proposal is to let's just get going with this. Much more easily said than done, I can assure you. So what is it that you would like me to say to the General Assembly should they ask? Bill?
Well, I think they should look at it a little bit closer. I'd ask the group here today how many can explain the state aid formula and what the weights are and why they were derived for the way that they were. The weighting study gives a good background on that, but there are a lot of on-the-ground technical decisions. I don't see this as a political group as much as they would have to have statistical knowledge, state aid experience, things of this sort. In other words, why don't we design the plane before we try to fly it? This is my thinking.
Thank you. Are there other thoughts?
Can I, this is Peter. Can you hear me?
Yes, we can hear you, Peter.
I'm going back to this task commission. I don't know if everybody's familiar with it, but there's been this study that happened in 2011, and this is kind of redux, about really revamping how we fund education, and it's really talking about a serious overhaul of how taxation, doing services and whatnot. And it seems like the governor, so long as it meets his concerns, it seems to have legs. And I'm curious if anybody else has any thoughts on that, because it puts the weighting study. This would do away with all of that in one fell swoop.
Peter, do you know if there's been any legislation to implement the recommendations of that?
No, it's just a study committee, but my takeaway was that the governor is saying he could support this. He could support going to an income tax for education and whatnot, and really revamp the taxes, the service tax, increase in sales tax, et cetera, are all part of a big, broad picture that are being considered right now. And what, in 2011, there's a similar proposal, but it didn't go anywhere. For some reason, this has got some legs, it seems, and I'm very pleased that the governor has been willing to say as much as he has. So.
All right, thank you, Peter. Jennifer, you have a comment or question?
I did, but Oliver, was your comment in response to Peter? Do you want to go first?
Yeah,
ahead, Oliver.
I'll put my former Ways and Means hat on, and I want to just be really clear that how we fund education is very different from what the weighting study is looking at. They're two separate issues. The weighting study is purely looking at how the money is spent. That taxation committee is just looking at it, and the two are almost completely divorced. So I wouldn't mix the two up.
And Jennifer, now, do you wish to speak?
I do, thank you. So just in considering the fact that I'm in Southern Vermont and as compared with the rest of the state, many of our towns, the families end up sending their children to independent schools. My biggest concern with the weighting study is I believe right now the determination of poverty is basically based on the number of students receiving free and reduced lunch. And that is a calculation that is really only geared toward public schools. It doesn't really capture the children in poverty at independent schools. So while I fully support the need to tweak the weights that are assigned to different categories of students, I think now is the time to make sure that that's done in a more even-handed way that fully captures all students in Vermont, regardless of where they attend school.
Thank you for that point. Kim.
Thank you. And I may be getting this wrong, but I thought that I understood the weighting study to have been commissioned and viewed through the lens of the current education funding system, and that there is reference to that in the study. So while completely understood that the way of funding education is not specifically the weighting study, I think the weighting study was conducted in the context and with deference to the current funding system. So I'm not sure they're completely divorced. I appreciate fully that they are entirely separate issues, but not entirely divorced from one another. And so I guess I just put that out there as a caution. There feels like a lot of moving parts, but there's also some urgency in recognizing something that I think literally has been spoken about since I have begun board service, this notion that our current weights do not accurately reflect the cost to educate students in those categories. So I think that there is value to the study and importance in thoughtful considerations regarding implementation. And that really needs to avoid the winners and losers arguments, because then you really will get nowhere, but rather think about it through the lens of equity for outcomes for all students, for every student. And then the only other thing I'll say, Jennifer, I think one of the other things, and you raise a good point regarding free and reduced lunch, is and Dan, you can correct me if I'm getting this wrong, but I'm pretty sure it is that much harder while we are offering free meals to all students under, since the pandemic. At least we are in our school district. I'm pretty sure that's happening. That getting those forms, I don't know how accurate our numbers will be regarding free and reduced lunch in this environment right now. So I may be wrong there, but that's my assertion.
Well, and for what it's worth, FRL is a pretty crude proxy for poverty. I mean, it's the one we use, and it may be the only one available, but I see Shannon nodding, who is up close to this. Peter, this is a question for you. Are you there, Peter?
Yes, I'm here.
You said that this proposal from 2011 has legs.
No. The proposal of 2011 didn't go anywhere. It was a similar transformation how we fund education as to what is being discussed now.
Okay, what proposal has legs?
Well, I'm just talking about what this tax commission and the what's been happening that seems to have it built some momentum, and it may have to do with the governor's participation, but he has an open mind to really looking at how we fund education and in fact how we raise taxes. One of the concerns is that where the sales tax just isn't working, and the service taxes is going to be looked at and whatnot. So it's a whole array of some dramatic changes that they are considering. Oliver or others may know whether how much this will gain some momentum, but the fact that they're discussing with the governor there, I think is noteworthy.
And this tax commission was created by statute a year or two ago.
I do not know how it was formed. I don't know that. I don't know. I doubt it was done by legislation, but I don't know that.
Okay. Secretary French, you've had your hand up. I'm sorry.
Yeah, just a lot of ideas. I just want to point out the current weights do not use free and reduced lunch. We use a poverty indicator that comes from poverty information we have through the census and other
Thank you.
State agencies. And I think, to the governor's interest in this, I think we're all interested in the idea, certainly, but I think I've heard him express some concern, not so much about how the revenue is raised, but the spending issue as well. And that's been a primary focus, and the two are not the same. And I'd probably situate the weighting study as somewhere in between. So we have the issue of revenues and then the spending, but in between is the machinery by which we allocate those resources. And that's kind of, I think, where the weighting study is more appropriately situated.
Right. Thank you. Thank you. I guess, Bill, your position is that we still ought to have an outside committee of experts.
Yes, and the more we have this discussion, we begin to see why, because it is terribly complex, and substituting FRL, getting rid of that is long overdue. But then how good is the indicators that we have otherwise? And there's just a great number of technical kinds of questions that need to be worked out. We're not ready for prime time. There isn't, because there is the weighting study, doesn't mean they can go out the door. And I think Tammy would be the first person to say that it needs implementation kind of work. So I think that's where we are.
Thank you, Bill. Oliver, your hand is up.
I'm going to suggest that perhaps we not take a position on how to move forward with the weighting study. Only because it's a little outside of what we're going to be directly tasked with addressing, and I feel like we have enough on our plate as it is. It may be best just to leave this to the legislature without passing comment on how they should best move forward.
Thank you, Oliver. Kim, and then Bill.
I think I was going to suggest that maybe we aren't prescriptive, but that we, if asked, we could frame it in the context of ensuring that the implementation is done in a way that allows for building capacity for those districts that might receive more funds and for those that might be at a tremendous loss of funds. So it lends itself to a measured transition. And I don't know if that's broad enough, or, the notion of it better reflecting equity and the opportunity to, and the costs of educating. So are there broad statements that we could speak to? And then I think it begs the question whether or not we add anything to the conversation if we're asked, because I'm not sure that lends much to it. And I don't know that we end up having a particular role in it, although I guess we'll be called upon for rules.
I think your point about building capacity is a good one. And my guess is that that's being thought of, but would be no harm in mentioning that as a piece of this. I do think that we don't need to talk or lecture people about equity. I don't think these legislators would have signed on to this if equity were not a very high concern for them. That is, the implementation of the weighting study is all about equity. So anybody who's sponsoring legislation or taking it up is, I think, probably way ahead of us on their commitment to equity. So I think I'll sort of try to, I'm sympathetic to Oliver's point of view. And if pressed, I think I would mention the question of capacity to make effective use of enhanced funding in those districts that would receive it. So if we can leave it there, I would like to do so. The other legislative matters, data suppression, don't know what that's going to look like. State aid to school construction, we have no idea. Reform of the state board, of course, I'll be working on that with the various committees that seem to have an interest in it. I would like to move. We have 5 minutes left. I'd like to shift gears. Oliver, you have your hand up. Can we very quickly hear what
Yes, very quickly, just on the reform of the state board, per our earlier conversation and when we've had prior to that, I just want to see if the board is amenable to formally recommending that we transition that investigative piece of related to financial capacity over to the agency, so that we have the consistency.
I could certainly include that in the transition that we've already worked out with many other pieces. Dan's very firm that he wants the state board to stay in sort of regulatory control of independent schools. That is the approval process and all of that. And in a way, by doing what you're making reference to, that affirms the board's exclusive role in the approval process and also affirms the agency's exclusive authority to investigate.
Yep.
I can certainly include that in the discussion. Happy to do so.
Great, thank you.
All right, board, we have 5 minutes before we take a 5-minute break to make a transition. Let me just speak about that transition. At 1:30 sharp, and Maureen, maybe you can confirm whether Amanda, yeah, I think I see Amanda Garza is already on. Amanda Garza will present and lead us in a 2-hour training and discussion related to implicit bias. That starts at 1:30. We will take a break at 1:25 to allow the RETN people to sign off. Our discussion will not be carried by RETN. Dan, you've probably had this sort of training, so if you feel you have other pressing things to go to, that's fully understood. Other board members, I really expect you to stay here for this. Before we get to that, I just want to mention sort of upcoming agenda. In our February agenda, we will, as you saw, receive a developed presentation from Kim and her committee regarding 132360. Oliver will have some recommendations from his committee regarding 2200 and the 173 pieces of that. We will have a second part of our training, which will be another 2 hours at the end of the February meeting. We will have a presentation from I'm stumbling over the name, but the short form of it is the racial and ethnic studies. That's a short form of the title group, which you heard from Amanda Garces, who is the chair of that group. I think it was in August that she spoke with us, and we promised that she would come back at the beginning of this year. They have now developed a series of very specific recommendations for changes in the board's rules. So, rules are beginning to become a very important part of our lives these days. And the Ethnic Studies Group has a number of particular proposed changes that they will present to us. And Amanda and I have agreed that she and her colleagues will present to the board at the February meeting. That, and who knows what else will come down the pike. It'll be another very packed, intense meeting. So with that, it's 1:24, and we'll just sort of be at ease. You don't need to go anywhere. But this would be the time to our friends at RETN. Marcy, I see you're on the line. This would be the time for you folks to pack up your gear, metaphorically speaking, and bring to an end your coverage of this January meeting of the State Board of Education. We thank all of you viewers for having an interest in the State Board, and we will continue on with a board training. Thank you very much. So.